Hi, my name is David P Shapiro. I'm the owner and managing partner of the law office of David P Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk about specifically in California, if you start a fight, can you then claim self-defense? And what's really important is what to look at here is the actual law. So I want to break that down. And that's from crim 3471. Now, crim is a fancy word for the California criminal jury instructions. Okay, and that's what a jury has to determine and what they look at when determining whether or not a defendant has been convicted or whether he should be convicted, whether the case has been proven beyond a reasonable doubt. And I'm reading from that statute. In order to claim right to self-defense after starting a fight, you need to first make a good faith attempt to stop that behavior. You must opponent that a reasonable person will believe that you want that fight to stop, and that you gave the opponent a chance to stop fighting. So, a lot of people thought when you're looking at Kyle Rittenhouse, like, hey, how would that case have shaped out in California with that jury instruction? And that would have been very interesting, right? Because you look at it in California, would walking around the street with an AR-15 pointed at people, or brandishing it, right? Would that have been enough? And California is obviously different with open carry than the state of Wisconsin, but we see it a lot of times where, someone gets in a fist fight and they initiate a fist fight, the other person fights back, pulls out a weapon and takes it to a whole fight. It's like, well, it's not that simple because you actually started the fight. And what do we need to look at? We need to look at crim 3471 to determine whether or not you then have foregone or given up your right, basically, or abandoned your claim to self-defense. It's not to say you can't run with it and try it, just probably not going to get very far with it. So that's really, really important when looking at self-defense law. What type of force? What was the reason for self-defense? What did you know, right? What did you know about the other person's background, their propensity for violence, if any? What have you heard about their propensity for violence? Were they? It's always relevant, but it's easier to get into evidence a lot of times because it is so important as to what was going on. And you had to be mindful of the fact that just because you're in you could take it to a new level and say, oh, self-defense. So keep that in mind, and the best thing to do, right? Whether you're accused of something involving where you might have a viable self-defense, you're contacted by law enforcement, say, hey, did you have self-defense? Why'd you do this? Did you think? Politely decline to answer those questions, because why would you say things that could then close the door to possible defenses? Why would you say things admitting that, let's say, yeah, I started the fight, and then all of a sudden you've boxed yourself into 3471 of the jury instructions as opposed to an open-ended self-defense? Whatever happened, but you don't want to close doors to certain defenses, particularly when you're dealing with self-defense. So the best thing to do would be not to answer any questions, to politely decline to answer any questions, and to reach out and consult with and then hire a local quality experience who has experience dealing with self-defense cases. Okay, so if you find yourself dealing with a situation where you believe maybe your only defense at all, but you want to talk about it and learn more about it and how it may be applicable to your case, particularly in California, give my firm a call, 619-295-3555. Diego Criminal Attorney.